afternoon, ladies and gentlemen. This is the 2840th meeting of the Human Rights Committee. We are examining the second periodic report of Kuwait today. But first, let me welcome the distinguished delegation from Kuwait, headed by His Excellency Mr. Dara Razuki, the head and ambassador of the permanent mission of the state of Kuwait here in Geneva. Your Excellency, let me briefly explain how we're going to proceed. We are going to give you time to present your opening statement for about 10 minutes, and as has been requested, you will then follow this with a summary of the written replies to the list of issues for about 20 minutes, after which we will then open the floor to members of the committee to pose questions based on the first half of the list of issues, and that is from number 1 to 18. So with that, I give you the floor to make your opening statement. Thank you.
Thank you, Madam Chairperson. I thank you very much, and distinguished colleagues, for your statements. And I have the honor, of course, to present Kuwait's report in front of the committee. First of all, I would like to introduce my delegation to the esteemed committee. My delegation is consisting, of course, of me as chairman of the delegation, and I have مستشار صادق معرفي وفد دولة الكويت، مستشار طلال المطيري وفد دولة الكويت، الملحق الصحفي نواف نعمان وفد دولة الكويت، اللواء خليل الشمالي وزارة الداخلية، العقيد
Ministry of Interior, Colonel Mansour Al-Hajiri, Minister of Interior, Colonel Jaber Al-Anazi, Ministry of Interior, and Dr. Mohammed Al-Mutairi from the Ministry of Interior, Dr. Mohammed Al-Wahaib, Director of Information Department, Ministry of Interior, Mr. Zakaria Al-Ansari, Ministry of Justice, Mr. Saud Sal Al-Salana, Public Financial Administrative Prosecutor, Mr. Saud Al-Safidi, Ministry of Foreign Affairs, Mrs. Fajr Al-Buayjan, Wazarat Al-Khariji, Ministry of Foreign Affairs, Dr. Zaki Salah Al-Sulaimi, Ministry of Social Affairs, Mrs. Amira Ghazi Jahwar, Ministry of Social Affairs and Labor, Mrs. Iman Al-Nasir, Central Bureau for Illegal Residents, Mr. Salah Al-Safidi, Central Bureau for Illegal Counselor, Dr. Salma Al-Ajmi, Dr. Hoda Al-Shaji, Committee on Women's Affairs, and
a report with my delegations, and you have noticed very well that my delegation is widespread from all different ministries and from all different sections in Kuwait in order to respond to your inquiry and to your questions. I will state my statements in Arabic, Madam Chairperson. Sayyida Raisa,
Madam Chairperson, it is our pleasure to present to this esteemed Commission a detailed presentation of the report of the State of Kuwait concerning the International Covenant on Civil and Political Rights. The State of Kuwait is very keen to cooperate in strengthening human rights and human dignity. Madam Chairperson, when the State of Kuwait drafted its permanent constitution, it ensured that the clement Islamic Sharia law and the international declarations and conventions were its main sources. These sources comprise provisions that protect and strengthen human rights. And in order to ensure the application and enforcement of laws and legislation protecting human rights, Kuwait's legislators have sought to have an independent, fair, and free judiciary capable of taking independent decisions without any interference. Hence, Kuwait's constitution comprises articles that are clearly similar to those enshrined in the International Covenant on Civil and Political Rights. Article 29, for example, states the principle of equality in rights and responsibilities without any discrimination. Article 166 stipulates the right to have access to courts in addition to the other articles related to political participation and laws ensuring civil and political rights. When Kuwait acceded to above-mentioned convention, law number 12 for 1996 was promulgated and thus became a part of domestic laws. When presenting its UPR related to the national report of May 2010, the state of Kuwait committed itself to establishing a national institution for human rights in accordance with the Paris Principles and has achieved great strides in setting it up, which reflects its interest in all matters related to human rights. Madam Chairperson, the state of Kuwait has made numerous achievements related to civil and political rights. These are as follows. The right of life is an essential pillar underpinning all human rights as it ensures human life itself. Therefore, the state of Kuwait considered this right to be of great importance and took several measures to protect it. As far as human dignity is concerned, the state of Kuwait provides citizens with decent housing as well as free education and health care free of cost. These rights are stipulated in the Constitution. Moreover, the state of Kuwait has also sought to combat all forms of forced labor and human exploitation for unlawful purposes. Article 42 of the Constitution states that there is no forced labor except in the cases specified by law for national emergency and with just remuneration. The state of Kuwait ratified the United Nations Convention against transnational organized crime and the protocols thereto. Many achievements have been reached in the field of women's rights, such as the election of 4 women as members of the National Assembly after gaining full political rights. There is also the right to housing, equality with men in public appointments and in the private sector, and the right to travel and movement. The state of Kuwait has offered care to persons with disabilities and thus ratified Law 8/2010, which provided them, as well as those taking care of them, with many privileges, including rights to financial and material aid. This law also stipulated the creation of a public institution charged with providing care to the disabled and facilitating their reintegration into society. Concerning the issue of illegal residence, Kuwait has responded to the recommendations received during the UPR on this issue and thus has created a central institution to tackle their concerns, and thus they have received several privileges, amongst which are free health care, free education, and last year there were 12,218 students that benefited from this privilege, documentation of marriage contracts, passports. There were 5,278 passports issued. death certificates, there were 520 issued this year. Food ration cards, there were 10,494 cards issued for this year, and they benefited on equal footing with citizens from receiving a one-year supply of food rations free of charge. These privileges will pave the way to end this humanitarian issue within the next 5 years. Madam Chairperson, the report we presented today is just an addition to previous reports submitted by the State of Kuwait and a record of the developments that took place in terms of the realities of civil and political rights. Many achievements were made, and we have aspirations to achieve better results. This is not the end of the road. We remain open to apply all measures to bolster human rights, and we welcome your questions and recommendations concerning civil and political rights. Lastly, we would like to present to you and the esteemed Commission our deep appreciation and heartfelt thanks for your constant interest and constructive follow-up of issues of human rights and dignity within your search for the best ways to make these rights a reality, and would like to wish you all the best of success in this great humanitarian endeavor. Thank you, Madam Chairperson.
I think now you ask me, Madam Chairperson, to give the floor to Mr. Saud Al-Harbi, who will speak for 20 minutes to explain exactly how we prepared the report. Saud.
Thank you.
Welcome. After your permission, Madam Chairperson.
With pleasure.
Bismillah. Walhamdulillah.
Thank you, Madam Chairperson. In the name of God, the compassionate, the merciful. Madam Chairperson, issues of human rights and dealing with them in the state of Kuwait are not new. Such rights are anchored in Kuwait's Arab, Islamic, and international heritage, a heritage that is deeply rooted in Kuwait's history since its inception, and to this very day. Kuwait will always uphold and respect this principle. The respect and consideration shown to human beings, both as individuals and as members of society, are clearly reflected in Kuwait's practices. At the time of drafting its constitution, the state of Kuwait adopted a comprehensive outlook of all human rights and considered existing international declarations and covenants as key references. Thus, the Kuwaiti constitution is actually an enforcement and an application of such covenants and instruments, including civil and political rights. In this connection, the state of Kuwait acceded to the International Covenant on Civil and Political Rights and endorsed it by virtue of Law number 12 for 1996, making this covenant part of its internal binding laws. To ensure an adequate monitoring of human rights issues, the state of Kuwait, by virtue of ministerial Decision number 104 for 2008 established the High Committee for Human Rights headed by the Minister of Justice. In this same respect, Kuwait committed itself during the presentation of its national report to the Working Group on the UPR in May 2010 to setting up a national constitution for human rights in accordance with the Paris Principles. Through the cooperation of the authorities concerned, the state of Kuwait has made great strides in establishing this institution. Madam Chairperson, it is our pleasure to review the efforts undertaken by the State of Kuwait in order to activate the governance components and ensure their implementation, and such efforts are reflected in the following points. The right to life. The State of Kuwait has paid special attention to the right to life, one of the primary basic rights. Such attention is reflected in providing health and education and all other services that protect human life. The state's constitution, legislations, and laws took into consideration and emphasized such a right. With regard to right to human dignity, a matter of immense importance to the State of Kuwait, is protected by laws. Article 29 and 31 of Kuwait's constitution, among others, stress equality and human dignity, and that no person shall be unlawfully arrested or subjected to torture for any reason whatsoever. In case of abuse, the law stipulates that perpetrators should be quickly brought to justice within a reasonable delay. If convicted, the person would be then put in prison, which is considered a correctional institution, to reintegrate those inmates once their sentence is exhausted. Whenever public interest is at stake and there is a need for an administrative expulsion for a non-Kuwaiti, this procedure is in no way absolute, and such expulsion is done within the framework of law. The State of Kuwait has always sought to safeguard the dignity and rights of foreign workers, irrespective of their social status or the nature of the work. Keeping a foreign worker's passport by the employer is unlawful. These workers have the right to proper accommodation, food and health care, which is stipulated in the work contract, and the worker has the right to seek justice should the employer violate these terms. Within its national borders, the State of Kuwait has been particularly vigilant against any form of forced labor or slavery. Its laws brings punishment to any person who brings another person in or out of Kuwait for use as a slave, buys, sells, presents, gives him as a gift. Thus, Kuwait has endorsed the United Nations Convention against Transnational Organized Crime and the protocols thereto. As for illegal residents, the State of Kuwait set up a central authority to deal with their situation. This authority has provided them with many civilian facilities, privileges, and has taken up many measures for their benefit. These comprise free education and health care, issuing marriage, birth certificates, death certificates, driving licenses, services provided by the Public Authority for Special Needs in accordance with Law Number 8 for 2010, and power of attorney certificates, food supply cards, employment opportunities, as well as many other facilities and privileges. Madam Chairperson, the State of Kuwait recognizes the right of citizens to own property and housing by providing through the Savings and Credit Bank of Kuwait or through services interest-free loans and allow direct purchase by individuals. Recent laws have allowed Kuwaiti women to enjoy these banking facilities as well. The law also regulates the mechanisms by which foreigners could own in Kuwait, while Ministerial Decision number 259/2010 stipulated establishing a committee entrusted with reviewing applications of non-Kuwaitis seeking to own property and defining general policies governing property ownership by non-Kuwaitis. Madam Chairperson, the state of Kuwait seeks to establish peace and security. This is why Kuwait categorically refuses violence in all its forms. Such rejection was stressed in the Penal Code number 129 and 31 for 1970, and Article 56 of the Penal Code actually criminalizes and punishes any form of cruelty. Examples of violence include domestic violence and its subsequent prejudices are criminalized by virtue of Articles 160 to 164 of the Penal Code. In case of actual domestic violence, the state of Kuwait has taken many measures aimed at encouraging women victims to report to the police should they fall victim to domestic violence or sexual assault. In this respect, the Ministry of Interior set up a special department called Community Police. This force has been entrusted with following up these cases and providing social and psychological support to victims. When the Ministry of Interior receives complaints of domestic violence, it immediately tries initially to reconcile the parties concerned with a view to safeguard family ties and protect both parties and children in line with the values of Islam and the traditions of the Kuwaiti society. Article 126 of the Personal Status Law guarantees the right of the wife to separate based on injury she sustained. This article is based on principles of the Islamic Sharia on matters related to marriage and divorce. Violence against children, we would find that the issues referred to in terms of punishment in case of domestic violence against women apply also to violence against children in all its forms, whether these be physical or spiritual and committed in family circles, schools, or elsewhere. With regard to freedoms, the Constitution of the State of Kuwait comprises many articles that stress human freedoms. Some of these are as follows. Freedom of belief. Freedom of belief, whether such freedom is practiced by the person himself or herself or by refusing to force a person to convert to another belief. Article 35 guarantees the freedom of belief for all persons residing on its territory, regardless of their affiliation and ethnicity. It also guarantees the freedom of practicing religion in accordance with established customs, provided that it doesn't conflict with public policy or morals. The freedom of opinion and academic research is guaranteed by the Constitution. Everyone has the right to express one's opinion, publish it orally or in writing, in accordance with the prevailing situation and as stipulated by the law. Article 147 of the Penal Code states that fair criticism made in goodwill with regard to a court order does not constitute a crime, whether such criticism related to facts or to the application and enforcement of the laws. Articles of the Constitution and other laws comprise Law Number 9 for 2001, which criminalizes the misuse of telecommunication equipment. This law forbids wiretapping unless there is an express warrant from the general prosecutor. Law Number 3 for 2006 on publications and publishing ensures the right of everyone to express himself or herself and provides compensation for those who suffered damage thereof. As for general public rallies, individuals have the right to hold rallies in accordance with rules and regulations stated by the law. These aim at safeguarding public interest. A draft law is presently being prepared to amend some articles of Law Number 56 of 1979 concerning public rallies and gatherings, and is being included on the agenda of the National Assembly at the present moment. It should be stressed here that the right of association is guaranteed for all workers. Law number 6 for 2010 on the private sector labor does not include any article that prohibits non-citizens from joining trade unions. Madam Chairperson, the above is just a brief summary of human rights in Kuwait as practiced. Such practices are in accordance with all declarations and conventions that the state of Kuwait acceded to, and in fulfillment of the Constitution's articles, the sovereign guarantor of all the rights that Kuwait set for itself. Islam is the religion of the state, and its provisions are, in general, major sources of legislation, especially the personal status law. Madam Chairperson, the state of Kuwait shall do its utmost to follow on the latest issues concerning human rights, with a view to assessing their development in order to implement and protect them. In conclusion, we wish to extend to you and to all members of this committee with our gratitude and appreciation for your endeavors in the service of peace, security, and democracy, wishing you every success for all the efforts made by all international organizations. I thank you very much, Madam Chairperson.
I'm sorry, I forgot to mention the name of Dr. Mahmoud Abdelhadi. He is Ministry of Health. He is among us. And Mrs. Rania Lemlefi, Kuwait Mission, she is also participating with us. Thank you.
I thank His Excellency and Ambassador of the State of Kuwait, Mr. Dara Razuki, for your opening statement and for allowing us to hear a summary of the replies to the list of issues. I will now open the floor to members of the committee to pose any questions they have for issues 1 to 18. And I'll begin with Mr. Newman. You have the floor.
Thank you, Madam Chair. I would like to begin by warmly welcoming the distinguished delegation of the State of Kuwait and express my pleasure at the size of the delegation and the extensive expertise that will be brought to bear in this dialogue. I look forward to a constructive and fruitful discussion of the second periodic report. The first question I would like to ask concerns question 1 on the list of issues. Question 1 concerns the status of the covenant in domestic law. Having read the reply to the list of issues, I'm still somewhat uncertain about the status of the covenant in domestic law, and I hope that you can clarify this for me. It appears to suggest that the covenant as a treaty takes precedence over legislation that existed in 1996 if they conflict. Is that correct? It leaves somewhat unclear whether subsequent legislation that is inconsistent with the covenant takes precedence over the covenant in the domestic legal system because they have equal rank and the legislation is later. Is that indeed the situation? And what types of legal norms have equal or greater rank than the covenant in the domestic legal system? Second, the reply suggests that the covenant could possibly be invoked directly in the courts, but it does not give an explicit explanation and gives no examples where this has actually happened, although we asked for examples if any exist. Should we conclude then that there are no examples where the covenant has been invoked directly in the courts. Can the distinguished delegation explain why there are no examples, if that is the case? Third, how are the questions that I've been raising just now affected by the state party's interpretive declaration to Articles 2, Paragraph 1 and 3 of the Covenant? The interpretive declaration also appears ambiguous. It could be interpreted to say that the rights under the Covenant are accepted only within whatever limits Kuwaiti law sets from time to time. If that were the case, then the declaration would be inconsistent with the rights, and the committee would have to regard the declaration as invalid. What effect does this interpretive declaration actually have within the Kuwaiti legal system? Will the state party withdraw this interpretive declaration in order to make clearer the nature of its commitment to the covenant? Question 2 regarded the issue of a national human rights institution. I thank the distinguished delegation for the answer concerning the project for establishing a national human rights institution. And for now, I would only ask for an update concerning the progress on this project since the filing of the replies to the list of issues. As is our habit, I will now jump from question 2 to question 12 so that I ask all the questions that are my responsibility before we move to a different committee member. Question 12 concerned the rights of persons detained awaiting deportation. The covenant protects the human rights of all persons and not only the rights of citizens. I thank the distinguished delegation for the information contained in the reply. There are some uncertainties that I have that remain. Can I ask, if a person has been ordered deported but has not yet been deported, is there any maximum period that the person can be detained before he or she must be released? The reply refers to delays of a few weeks or a few months, but sometimes deportation can take longer to carry out for various reasons. Perhaps the lack of cooperation of the other state, or perhaps because the person is stateless. Is there a maximum legal period of detention? Can the person resort to the courts to get review of the legality of the detention, either because it is unjustified or because it has lasted too long? Does a person alleged to be deportable have a right to be heard on the merits before deportation is ordered? For example, if there is a dispute between the person and his or her employer concerning the relevant facts. Does the person have a right to be represented by counsel and a right to be That's a repetition. Finally, regarding the conditions of confinement in the Tala Deportation Center, can I ask the state to comment on those conditions? Are they satisfactory? Are the conditions of confinement subject to inspection by an independent monitoring authority? Those were the questions I wanted to ask in connection with question 12. We turn next to question 13 concerning forced labor. The question asked initially whether exacting forced labor is an offense under the criminal code, and the reply referred to offenses committed by public officials and also to offenses related to slavery, or at least that was the terminology used in the English translation. May I ask, do these offenses cover all cases of forced labor, including the exaction of forced labor by private employers who use coercive methods? I was not sure from the translation whether older institutions of slavery are referred to or whether all modern forms of forced labor would come under this definition. Second, the question requested statistics concerning hard labor in prisons. The reply gives information about the law and the categories, but no statistics. I would be grateful to receive the statistics if that is possible. In this matter, as in all matters, the committee is interested both in what the laws say and in what actually happens in practice. Question 14 regarded the sponsorship system. Many employers have used their control over the presence of foreign workers in Kuwait to impose unlawful working conditions on their employees. The committee is interested in the efforts the state party is engaged in to prevent this problem, partly by enacting laws, but also by enforcing laws and by punishing employers who violate them. Thus far, it appears the state party has not abolished the sponsorship system, but has adopted some additional regulations which apply to certain categories of employees. Has the state party considered that under existing conditions it may be necessary to abolish the sponsorship system altogether? The reply states that under a new ministerial decision, in certain cases employees can transfer their residence permit to another employer. May I ask what categories of employees does this rule apply to, and under what conditions? The reply affirms, and it's been affirmed already today, that passports belong in the possession of their owners and cannot be lawfully held by their employers. But is this legal principle enforced? In cases where employers violate this rule, are the employers punished? I observed that the 9th article of the Private Sector Labor Law of February 2010 requires the establishment of a public authority for the labor force to administer some of its important provisions. We've been informed that this authority has not yet been established. Is that correct? And when will this authority be established? Let me turn next to question 15, a related question, but one relating specifically to domestic workers. There are over 600,000 foreign domestic workers in Kuwait. They work in isolation and are highly vulnerable to violation of their rights by their particular employers and by the agencies that arrange their placement. May I ask, why were they excluded from the new private sector labor law of 2010? One might think that domestic workers are more in need of protection rather than less need of protection than other private workers. Again, the reply regarding confiscation of domestic workers' passports does not identify any steps that are taken in practice to enforce the principle that such confiscation is unlawful. Are employers of domestic workers ever punished for such confiscation? Does ministerial decision number 194 of 2010 on this subject also apply to domestic workers, or are they excluded from the scope of this provision as they were from the scope of the private sector labor law? When domestic workers are abused by their employers, does the state party permit them to seek alternative employment in Kuwait, or even facilitate their placement with employers who comply with the law, rather than requiring them to return to their countries of origin? I thank the distinguished delegation for the statistics provided in the reply on enforcement actions against enforcement actions against employers. The numbers provided are extremely small given the magnitude of the problem. May I ask, what resources does the state party devote to inspection and investigation of labor conditions in the field of domestic work? Finally, question 16 regarding trafficking in persons. This is reportedly a very serious problem in Kuwait. Is it still true that the bill on trafficking in persons is pending and has not yet been enacted? When does the state party expect it to be enacted? And may I ask what is delaying its enactment? The reply to the list of issues refers to an older provision, Article 185 of the Penal Code, previously mentioned, regarding slavery. In this connection, again, can I ask, does this provision apply to the modern forms of trafficking in persons, or is it limited to older notions of slavery? Have there been any prosecutions under Article 185 in recent years? And if so, how many? I thank you for your patience in listening to all these questions, and I look forward to our further dialogue. Thank you.
Thank you, Mr. Newman. I give the floor to Mr. Flinterman.
Thank you, Madam Chair. I also would like to welcome most warmly the delegation from the state of Kuwait. It's a matter indeed of great satisfaction that the committee is now able to resume its dialogue with the state of Kuwait, which it started in the year 2000, 11 years ago. After the committee last met with the delegation of Kuwait, it included in its concluding observations the recommendation to the state that in its next report, the state should include gender disaggregated data and up-to-date statistic information on the condition of women, and that the state party was also requested to give particular attention to the recommendations which were included in the then concluding observations. And I welcome this opportunity to assess with the delegation whether and to what extent the state of Kuwait has heeded the recommendations of our committee in the year 2000. And we have already, through the report and through the introductory statement by the ambassador, heard about a number of important achievements in the field of human rights. I would like to highlight in this respect the very important step forward that women can now vote and be voted for, and that the state of Kuwait has consequently withdrawn its reservation to Article 7 of the Convention on the Elimination of All Forms of Discrimination Against Women. And having acknowledged this very important step in the context of gender equality, the question does immediately arise, why is it that that step has not been followed by also appointing women in the ranks of the judiciary? That would be my first general question. Madam Chair, Mr. Ambassador, my questions are based on the issues 3 to 7, and all those issues relate to what can be called a core principle of human rights, and that is the principle of equality and non-discrimination reflected in the Articles 2, 3 and 26 of the Covenant. It's a principle that human rights are inclusive. They include everyone. They do not exclude anyone. And I'm sure that in relation to the issue of gender equality, a number of the questions that I will raise have already been raised a week ago in the context of the examination of the report of the State of Kuwait in the Committee on the Elimination of Discrimination Against Women. But it's important to highlight some of the issues also here. And against that background, I turn to issue number 3, and I thank the delegation for the reply. My first question under issue 3 is it correct to assume, in light of the answer, that the state of Kuwait does not intend to criminalize marital rape? And if so, I would very much appreciate if the delegation could further explain the reasons for that. And likewise, is it correct to assume that the state of Kuwait is not intending to have specific provisions in its penal code on the issue of domestic violence, of which mostly women are victims? Domestic violence, violence against women, seen as a form of discrimination against women. And I've read the argument that the state of Kuwait thinks that the present provisions, general provisions on violence, are sufficient or also to address the issue of violence against women. But I would like to highlight that violence against women in itself justifies the specific attention also of the legislature. In that context, we have not received clear statistics on cases of domestic violence brought before the courts. And we have not received any indication of the number of safe shelters and hotlines, and neither of the number of complaints on domestic violence which have been filed since 2005. And I'm repeating some of the questions in issue 3. And here, at this point, at this juncture, I would also like to draw the attention of the importance of specific attention for the issue of violence against women, domestic violence, in the context of the protection of the rights of domestic workers, foreign domestic workers, especially female domestic workers. My third question under issue 3 is that in the year 2000, our committee recommended to the state of Kuwait that polygamy should be prohibited. And I noted in reading the answer that so far no action has been taken. And my question now is, could we get some information on how widespread the practice of polygamy is? And would the delegation agree with the view that polygamy in itself is a form of discrimination against women? My fourth question under issue 3 is that in the year 2000, the Human Rights Committee, our committee, expressed its concern that women and men who commit adultery are not treated equally, and that toleration of so-called crimes of honor add to the existing inequalities between the sexes. And from the replies to this particular sub-issue under issue 3, I've got the impression that polygamy is still allowed, is still not prohibited in the state of Kuwait. My question is, what has the government of Kuwait done to sensitize the population, as was recommended by the committee in 2000, so as to eradicate attitudes that lead to discrimination against women also in the field of marriage? Then I turn my attention to issue number 4, which relates to the inequality between women and men in relation to property and inheritance rights. And once again, not all the questions which the committee has raised under issue 4 have been replied to in the answers of the government. And I would like to repeat some of the important questions. Would it be possible, my most important question is, would it be possible for the delegation to clarify the current status of the draft law on civil rights of women? And especially I would like to have some information on whether this draft law will redress the still existing inequalities between women and men, such as, for example, the impossibility of Kuwaiti women who are married to foreigners or bidun to pass their nationality to their children. Then I turn my attention to issue as number 6. As I said in the beginning, human rights are inclusive, they embrace everyone, and that's reflected in the first sentence of Article 26. And in the second sentence, state parties have accepted the obligation to prohibit discrimination and guarantee equal and effective protection against discrimination on any ground, including sex. And sex has been interpreted by our committee and also by other treaty bodies to include sexual orientation. But yet we are informed that homosexual behavior is still criminalized in the state of Kuwait, and that prosecutions have been brought to men, in particular men, who commit homosexual behavior. We have been informed that in 2007, homosexuals requested the Social Affairs and Labor Ministry to establish a society for homosexuals in order to acquire, under the laws of the state of Kuwait, protection against harassment. And that particular request was refused. And my question now is, have any investigations since 2007 been undertaken with regard to allegations of harassment and maltreatment against homosexuals? And have any of those investigations led to prosecution? And is it the intention of the government of the state of Kuwait to reconsider its position on the criminalization of homosexual behavior? And then I come to issue number 7. That is the issue very much highlighted by the ambassador in his very informative introductory statement, the issue of discrimination on the basis of national origin. And of course, I'm referring to the Bidoun, or as it is called by the state of Kuwait, the illegal residents. That particular issue was considered to be a matter of grave concern by the committee in the year 2000. And in particular, the committee, in its concluding observations, emphasized that it was gravely concerned, and now I quote, gravely concerned over the sweeping statement of the delegation characterizing the Bidoun as illegal residents. This particular concern was shared by other treaty bodies, and also it was very much focused on in the framework of the UPR process to which the ambassador referred. And I have noted that recommendations in this respect have been rejected by the state of Kuwait. Well, reading closely the replies to the questions on the Bidoun issues and studying the information from other sources, I've come to the conclusion myself that the problem of the Bidoun, illegal residents as called by the state of Kuwait, is still there in all its magnitude. But at the same time, I've noted, as also indicated by Mr. Ambassador, that some potentially important steps have been taken, such as the establishment of what was called a central body or authority in November 2010, which is entrusted to find a solution for the Bidoun problem, and such as the decision of this body in early 2011 to grant a wide range of rights to the Bidoun, such as passports, Article 17 passports, and a number of certificates. But still, we have been informed that that particular decision is still pending in the National Assembly for approval, although today I got the impression that that approval has been given. Well, this particular problem, Madam Chair, is a problem which is in itself a problem of statelessness. The ambassador expressed his optimism that in 5 years from now the Bidoun problem will be solved. But as an outside observer, I have some hesitations because it seems that at the heart of the problem, is a denial of human rights, and in particular a denial of the right to citizenship. And for that reason, I would like to raise the following questions, and I would like to ask the delegation to reflect on those questions. And that is, first, would it be possible for the delegation, in light, to reflect on the question whether, in light of its obligations under the covenant, it would be possible for the state of Kuwait to ratify the 1954 and 1961 conventions on the status of stateless persons and the reduction of statelessness. Secondly, to reflect on the questions what obstacles there are for the Kuwaiti government to grant citizenship to the stateless persons referred to as illegal residents based on their long-term residence in the state of Kuwait. To reflect also on the questions what opportunities the state of Kuwait sees in order to work with countries in the region multilaterally towards finding solutions for illegal residents deemed to be of specific nationalities. And finally, to reflect on the question whether it would be possible for the state of Kuwait to take steps to ensure that stateless persons enjoy their right to return to the state of Kuwait. And what is also important, to create transparent application procedures for Kuwaiti nationality, including an independent review procedure. And then my final question relates, Madam Chair, to issue number 5, and that is the issue in which we are informed that in relation to the right to ownership, the right to property, a differentiation is made between Kuwaiti citizens and foreigners. And today we have received some information to the effect that in some situations there is a possibility for foreigners to own property in the state of Kuwait. And my question to the delegation would be to explain the reasons for these restrictive policies vis-à-vis ownership by foreigners of property in the state of Kuwait. Madam Chair, Mr. Ambassador, I'm very much looking forward to the answers to my questions. Thank you.
Thank you, Mr. Flinterman. I now give the floor to Mr. Taylin.
Thank you, Madam Chair. Let me first of all join colleagues in welcoming the distinguished and large delegation from Kuwait. I think the size of the delegation speaks in itself of the commitment which Kuwait shows towards the area of human rights. We have had delegations who have not been so large, so we look forward to boring into some of the details with which I will engage the delegation in. We also welcome, obviously, the report, although 5 years late, but in the broader scheme of things, 5 years is yesterday, because we do have examples of more expressed tardiness. I will concentrate on issues 8 till 11 and 17 and 18. Issue 8 is obviously in reference to the concern which the committee raised 11 years ago. And allow me to refer to the concluding observations in paragraph 8 of the committee on the issue of the death penalty, where the committee expressed serious concern over the large number of offenses for which the death penalty can be imposed, including very vague categories of offenses relating to internal and external security, as well as drug-related crimes, end of quote. And the recommendation was then for the state party to ensure that the provisions of Article 6 of the Covenant would be respected in the fullest extent. The question put to the state party is whether the state party would consider to accede to the second optional protocol. The answer is no. And the reason for that is given by reference to Islamic law, namely that the state of Kuwait is prohibited by its interpretation by Islamic law to actually abolish the death punishment. Now that gives rise to two questions on my part. The first one, I would be grateful to have the statistics on the number of death sentences that has been pronounced, and also to what extent they actually have been executed. Because 11 years ago, there were 28 inmates on death row. I would like to have an understanding of the development since 11 years ago. And I also ask these numbers because it has been put to us that when it comes to actually executing those who have been sentenced to death, there is a distinction made, it is claimed, between Kuwaiti citizens and non-citizens. There is a case involving a member of the Kuwaiti royal family, which was sentenced to death but not executed, whereas, for instance, Pakistani citizens have been both condemned to death and executed. So there seems also to be an element of discrimination in the carrying out of the death sentence, which of course raises concern in itself. The second question here is the reference in the reply to Islamic law. In the second article of your constitution, it seems that it's stated that Sharia is the main source of law. Now, if that is so, it raises the issue of whether Islamic law could be seen as superseding the obligations which the state party has under the covenant, i.e. whether this particular part of the Constitution is actually compatible with the obligations under Article 2 and Article 6 of the covenant. So that was my second question under issue 8. Moving then to issue 9, which is a cluster of issues dealing with alleged cases of alleged torture and cruel, inhuman, and degraded treatment on the part of police officers or prison officials. That's one cluster. The second cluster has to do with health care in detention facilities, and the third deals with the human rights training on topics of prohibition of torture, effective interrogation techniques, and the like. And I'm pleased to see the answer itself, because I think the question of the health facilities is satisfactorily answered, at least in my mind. And there's also a lengthy discourse on the prison facilities, the need to re-socialize prisoners and so on, and the inspection of prisons, for which I'm very grateful. However, there remains some issues, and that goes to the question of torture cases and how they are dealt with. There is an extensive statistics regarding abuse cases by police officers, and they are found then in the answer in paragraph, it's on the page 14, in the English, paragraph 48 and following. I have tried to compare the number of cases, and they are spread between 2010, there were some 233 cases, the preceding year, 267. That should then be compared with the table found in Annex 4. And here I'm deeply indebted to the assistance given to me by a colleague, Professor Newman, who helped me to decipher the Arabic, which the annex was in, and I'm afraid that we didn't have the possibilities to translate it. I then understand from that annex that's a much smaller number of the outcome of these cases. So there seems to be a wide gap between what's in the report and what's in the annex. It could be a very simple answer, namely that these cases are still yet not disposed of. There are still live cases, so there hasn't been a disposition. But I would like to have an explanation comparing the figures in the annex with what's in the report itself in paragraph 148. And also, as to the annex, I understand that there's been a couple of cases where police officers have actually been sentenced to prison sentence, in a couple of cases 1 to 3 years, in other cases up to 5 years. I think the maximum under the law is 7 years, if I understood the answer correctly. But in many cases, the decision was an acquittal or a fine or a settlement. I understand a settlement that the victim then has agreed to settle. That's understood. But there are also a label called no sentencing, and I just would like to know what that means. It doesn't seem to be an acquittal, but it doesn't seem to be a conviction either. So I just want to have that clarified. On this, the request was for cases involving prison officials, and as far as I can see, no information has been provided on that. So whatever you can give me on that, I would be most grateful. On issue 9, I would also like to know whether there is a definition of torture under the Kuwaiti law, and also whether there is an independent mechanism for investigating allegations of torture. It has been put to us by NGOs that exactly the same officials who are then claimed to be responsible for torture are the ones to whom you have to go in order to have the case investigated. And of course, that is not a proper way of dealing with it. And again, the same issue of discrimination has been raised here. Namely, it has been put to us that cases of alleged torture is considered more seriously if the victim is a Kuwaiti citizen. If he is not, the matter doesn't seem to interest the authorities. It's a claim that NGOs has put to us, and I would like to have the delegation comment on that issue as well. I then move to issue number 10, which is, I think, more or less satisfactorily answered because it deals with the question of the change in the law, which before made it possible to postpone the time during which someone is put before a judge. And it seems from the answer that there is now a draft bill which will reduce the time down to the 48 hours, which obviously would be more satisfactory. Again, it's an annex which I'm unable to read, Annex 5, but I take it that it is reflecting the bill. So my first question there is, when is this bill going to be adopted, and when will we have this in force? The second the question this is, I think the question also asked to the right to access to counsel, and no answer, I think, is given in that respect, unless it's hidden in Annex 5, but I'm grateful for the clarification also on that. And also, the remaining issue outstanding in issue 10 is to get an understanding of how many are actually subject to pretrial detention, and what is the average length of pretrial detention. That would give us a better understanding on how the system works. I now move to issue 11. In here, the question is very clear. It deals with how many persons have been condemned by military tribunals in 1991, and how many of those are still detained despite having finished serving their sentences. And will those cases be re-examined by an independent body? I can just note that none of these two questions have been answered. The answer seems to relate to an incendiary aspect of this, so the question remains. Moving then to the final two issues, and you should be relieved, Madam Chair. Issue 17 deals with the judiciary. The issue is to what extent the independence of judiciary is safeguarded. In the answer, we are given quotes from the Constitution, and obviously, taken on the face of it, it seems to be certainly in line with the requirements under Article 14. However, it has been put to us that the Supreme Judiciary Council, which in itself seems to exert important decision-making powers vis-à-vis the judiciary, is dependent on the executive in the shape and form of the Ministry of Justice. So, and if that is true, that the Supreme Judiciary Council is not so self-sustained in an administrative way, it raises questions of the whole independence of judiciary. So I would like to know the relationship between the Ministry of Justice and the Supreme Judiciary Council. It has been put to us that it would be preferable to have this council more closely connected with the Emir, the President, than with the executive in the shape or form of the ministry. Secondly, I have understood from information that we have been furnished with that there is a large number of foreign judges in Kuwait exercising judicial functions at all levels, including, I'm told, the Supreme Court. And I'm also told that the total number of the judiciary is 600, and that the number of foreign judges, many of whom come from Egypt, total nearly half, 50%, so 300. And the problem with this from an independence point of view is that the foreign judges are on a short-term contract, which obviously could be rescinded and abrogated in a way which would not be compatible with the right of independence of judges. So I would like to have you comment on how you see the independence of the foreign judges as part of your judiciary. I'm told very recently that a number of the Egyptian judges left because there was a dispute over salary, but also it have to do with that they felt that they were needed at home given the development that we have seen in Egypt this spring. That was issue number 17, and that brings me then to the final issue, 18, where the question is, how the provision in family courts that the testimony of one man is equal to that of two women is compatible with Article 14. And the only answer that the state party has given is the fact that this is laid down in Sharia law. Well, again, this brings me back to what I tried to explain in issue 8, which also links to issue 1, which Professor Newman put, namely the relationship then between the convention, including Article 14, and Sharia law, where obviously the position could not be that Sharia law supersedes the convention, because then, in essence, the obligations of the state parties are not fulfilled. I thank you for your patience, Madam Chair.
Thank you, Mr. Tellin. It is our usual practice to break for a few minutes to allow the delegation. Oh, Sir Nigel, I beg your pardon. I did not see that you wanted to take the floor. You do have the floor now.
Thank you, Madam Chair. No, I apologize. I had thought that they would be around for also for other colleagues who might want to intervene. I'm not quite prepared, but just a couple of things following up from issues raised by colleagues, in particular just by Mr. Tellin. And before doing so, if I could add my voice to those of the other colleagues to welcome this distinguished and impressive delegation from the state party. One relates to question number 10, issue number 10, and the question of who can order detention for how long. It's not quite clear to me. I understand that the initial detention can be for 4 days, and that the bill that Mr. Tellin referred to would bring it down to 48 hours, which is definitely a good thing. What I'm not clear about is what happens then. What authority can order further detention? Some of the information we have suggests that the general prosecution can order further detention for a further 21 days. Is that a correct understanding? And if so, at what point, if any, is the individual brought before a court? And of course, in relation to all of this, the point made by Mr. Tellin, which is when is there access to lawyers for a person who has been detained? So I look forward to hearing the answers on that. And there is also the related matter as to who is responsible for the custody. At what point is the individual taken out of the custody of the investigating authority, notably the police usually? The only other question I have relates to question 17. One could perhaps have also raise it in relation to issues in the second half, but I'll raise it now. And that is, it has been put to us that not only is a substantial proportion of the judiciary staffed by foreign personnel, which Mr. Tellin has just referred to, but that there are in fact no female judges. Is it true that there are no female judges? And a reason that has been given is that to be a judge one has to be able to be a prosecutor, and there are no female prosecutors. Is it true that there are no female prosecutors? And if there are no female prosecutors, why are there no female prosecutors? Is it true that their applications for candidacy are just not received, again, as put to us by non-governmental sources? And if it is a fact of qualification, that is, one has to be able to be a prosecutor in Kuwait in order to be able to be a judge in Kuwait, I'm not quite sure how foreign judicial personnel can qualify to be judges if the route of being a prosecutor is the route necessary in order to be a judge in Kuwait. These are all factual problems I have in terms of information brought to us by non-governmental sources that I'd be very grateful to the delegation to have clarification of. And in anticipation of that, thank you, Madam Chairperson, and thanks to the delegation.
Thank you, Sir Nigel. As I was saying, it's our practice to break for some minutes to allow the delegation to prepare its responses. So I propose that we break for 20 minutes, Your Excellency, yes, in order to allow your distinguished delegation to prepare. We should be back in the room just after 4:35. I suspend the meeting. I call the meeting to order. Welcome back, ladies and gentlemen. We shall resume with the responses from the distinguished delegation, for which I give the floor to His Excellency, the Ambassador, to take us through how this will be done. Thank you.
Yes, Madam. Thank you, Madam Chairman. I will try to proceed to give each member of my delegation the floor, but it might be more than one person who will be answered the questions because it's related to different sections in the ministry. So I will see exactly who is responsible according to the list I have, and then I will try to give each one the floor so he can answer in accordance with that. Now, when we come to, for instance, the first question by distinguished colleagues, I have Dr. Suad concerning the legal status of the covenant under domestic law and questions related to it. I will give Dr. Suad. She will try to answer and clarify certain position concerning the first question. Dr. Suad.
بسم الله الرحمن الرحيم.
دكتورة سعاد بالعدة الله يخليك.
شكرا سيدة الرئيس.
Thank you, Madam Chairperson. As a matter of fact, with the issuance of law number 1296, which approved the covenant, thus it has become a part and parcel of the Kuwaiti domestic law. And it falls within the organization, the legislation system. The Constitution of Kuwait respects all rights enshrined in the covenant, but the interpretative declaration on paragraph 1 of Article 2 and on Article 3 within the framework of civil rights related to the personal status law, considering that the organization is derived from Islamic Sharia, which is the main and the only source that of anything that has to do with personal status. And that is why we adhere to this declaration. I thank you, sir.
شكرا.
Thank you. I would like to add to what Dr. Suad has just said with regard to the legal framework of the enforcement of the covenant. The admission of the state of Kuwait and its observance, the observance of the covenant, is implemented in such a way as the judge will have to resort to all the provisions that fall within the corresponding framework. And here I would like to quote from a judgment by the Cassation Court, And and in a recent judgment by the Constitutional Court, which is the higher court or the Supreme Court in January 2008, here I quote, with reference to what has been enshrined in the International Covenant on Political and Civil Rights in terms of promotion of human rights and its fundamental freedoms. This has been stressed in para 2 of the covenant, namely that every individual has the right to leave his homeland. I thank you.
About questions of article, about questions number 12, and at the same time concerning is there progress in the Human Rights Council which Kuwait is adopting. I will comment on the Human Rights Council with the Ministry of Justice, but I will let concerning question number 12 about the person related to their detention and their detention and how. I'll give it to Mr. Mutairi. He is legal advisor in the Ministry of Interior. Dr. Mohammed.
شكرا سيد الرئيس. بالنسبة
Thank you, Madam Chairperson. With regard to detainees, with regard to the conditions of detainees by the Department of Prisons, the maximum period of detention before deportation, before going to court or before being tried, is 4 days. However, the draft that is being submitted currently to amend this period will be confined to 48 hours. During this period of time, the accused will be submitted to the prosecutor, and it's up to the prosecution to decide whether he would be released or would continue to be arrested until the lapse of 21 days, until all procedures of investigations would be completed. So during this period of time, he could be submitted to the concerned court, which would decide and adopt a judgment in this regard. The court may renew the detention period until all investigations are completed. During the investigations, the legal procedures in accordance with the penal code, it stipulates that each accused individual should be provided with legal counsel and should be secure, and all legal rights should be secured in such a way as to have a fair trial. And he has the right to contact his relatives, he has the right to contact his legal counsel, and if he is unwell or if he is having health problems, then he has the right to seek health care and health care. I thank you, Madam Chairperson.
Brigadier Khalil, for the conditions in the prisons, would you give us a briefing, please?
ما تكون يعني
With regard to deportation for those who are illegally residing in Kuwait, if there is a legal judgment in that respect, the first thing we do is we undertake a full investigation, and we make sure that he has his passport, and if he doesn't have a passport, we usually contact the embassy concerned, and then we then issue a card of departure by his embassy, and we usually issue him a ticket, and the fare would be handled by the employer. Sometimes there are some donations for the issuance of such air tickets. And 2 months ago, a commission by the Ministry of Interior, the prosecution, and the law enforcement has been established to look into all cases one by one, and I am always in touch with them, and I can get you further information on this issue. With regard to the numbers of deported people, it ranges between 450 to 500 persons. It all depends on the frequency of flights. With regard to the places of deportation for women, for domestic workers, yes, they live in proper conditions, and we are in the process of establishing or building a new building. It's not a prison. They are outside the premises of prisons. There are places for them to wait until they are being deported. Dr. Zaki.
الشكر موصول للسيد.
Thank you, Madam Chairperson. And I would like to thank Ambassador Zarruqi. There are some shelters and places of shelters that was established in 2007, receiving foreign domestic workers. And this center is providing social services, psychological services, and all kinds of services to all those domestic workers. Regarding the domestic workers who do not want to continue working in the state of Kuwait, we usually coordinate with the relevant embassies, and in this case they are being returned to their homelands after making sure they were fully paid in terms of their wages. So this is a temporary shelter, but the ministry has just finished the establishment of a center of support for domestic workers, and it can accommodate more than 700 domestic workers. Thank you.
There was a question about the progress, whether how we made the progress. I think in the UPR we made commitments that Kuwait will establish National Committee on Human Rights. And that's in accordance with classification A of Paris Principles. And of course, we engaged with the High Commissioner Office to see exactly what are the procedures for those classification, because as we know, there are 3 kinds of classification, A, B, and C. And we made commitment that it has to be A. So we engaged with the High Commissioner, and then we have last Monday, I have my colleagues here is for Ministry of Justice and my colleagues here in Kuwait Mission, we met with the principal experts concerning how to set up this commission and what are the procedures and what are the modus operandi and a lot of things to establish it, you see. We are proceeding in that direction. However, we were told that such a procedure will take a long time. It will take at least, in some cases, it took around 7 years, because you have to start yourself first, the procedure by appointing a certain number of people, and then you have to follow elections, and then you have, and then they have themselves to go back again to the national committees, and the national committees will, so it's a very, very long procedure. But we are on the right track, and we made such commitment, and I made such commitment in front of you, that we are proceeding in that direction, because this is the best way to protect and guarantee human rights in Kuwait. Dr. Zakaria, can you brief us a little bit on your negotiations with the High Commissioner?
Thank you, Madam Chairperson. As you have just mentioned, last Monday we held a meeting with the UN office, with the High Commissioner for Human Rights, and actually this decision has been taken by the Minister of Justice in order to implement that decision, namely the establishment of an independent commission in accordance with the Paris principles. We are in the final stages right now, and we will be adding further observations in light of the meeting that was held last Monday with the UN Office of Human Rights. With regard to the system of sponsorship, at the outset, I would like to assure you that the system of sponsorship is not enshrined in our legal system. As a matter of fact, it has to do with ministerial decrees that were issued within the framework of organizing labor of the private sector. The ministry is looking right now into finding an alternative for the system of sponsorship in consultation with experts from the ILO. And until we reach an alternative for this system of sponsorship, the Minister of Social Affairs has adopted a resolution that would allow the employee or the worker to be moved from one employer to another without prior consent by the first employer, within a time limit of 3 periods. This could be reduced to 1 year, and it could be lessened to a period that is less than that, depending on the situation of the institution where this worker is working. The ministry is keen on reaching an alternative system that would replace that system of sponsorship. However, we are taking every measure that is possible against abusive employers. That is, they import this laborers without giving them work. So, paragraph 6 of the Labor Code In Article 137, the penalty could reach imprisonment for 3 years or a fine that would amount to 5,000 Kuwaiti dinars. That is, if the employer is caught violating the law by importing workers without giving them any work. Of course, we do understand that the system of sponsorship has many negative aspects, but the general authority for employment is looking into finding another solution. But we are still looking into the establishment of this authority. Paragraph 9 of Law Number 6 for 2010 provided that an authority would be established according to, by virtue of a law, but this law has been submitted to the Parliament, has been submitted to the Cabinet, and it has been approved and has been conveyed to the Parliament, and upon approval, and the approval should take place in the next session of the Parliament starting the 25th of October.
Regarding domestic workers, sir, and whether domestic workers are covered or not by this law, there is a text in Article 5 which excludes domestic workers from this law. However, there is also a provision in this law that a competent minister may issue a decision in order to organize labor for domestic workers and to govern labor relations between domestic workers and their employers. There was also a question regarding the confiscation of passports. Regarding the confiscation of passports, I would like to assure you that this is legally prohibited. There is a principle in law that prohibits the confiscation of passports. This legal principle, of course, is enforced by all courts, commercial courts, labor courts. All these courts have prohibited the confiscation of passports. Moreover, the employer is obliged to compensate the worker if he confiscates his passport. If the employer violates this principle, he will have to compensate the worker. This is what I have to say regarding the sponsorship system and the confiscation of passports. As regards domestic workers, this is falls within the competence of the Ministry of Interior. Thank you. In the name of God, the Compassionate, the Merciful. There were a few questions on domestic workers, and I would like to add to what was said by my colleague Dr. Zaki regarding domestic workers and that they are not covered by the label in 2010 labor law. Domestic workers are governed by a decree which was issued in 1992, decree number 40/92 regarding the organization of domestic workers. The Ministry of Interior organizes and regulates the employment of domestic workers and the contractual relationship between the sponsor, the domestic worker, and the employer. There were a few there were a few questions regarding the fact that there is no law governing domestic workers. We do recognize that there is a shortcoming here. In 2010, a draft law was proposed by the Parliament. In 2010, the Convention on Decent Work was being discussed, and we felt that we should supplement this convention and enact a law on domestic workers. We are currently taking steps to establish committees to study the drafting of such a law. Regarding what was said about domestic workers, the fact that they were working in isolation, of course. You have to take into account the nature of Kuwaiti society and the nature of Kuwaiti families. Domestic workers do not work in isolation, especially female domestic workers. On the contrary, domestic workers are considered members of the family, and they share in the services and the benefits. However, our society is not perfect. There may be some forms of abuse. These cases of abuse are very rare, and the authorities are very strict. Any complaints made by domestic workers are investigated. If the domestic worker is attacked or beaten, these complaints are looked into seriously. The Ministry of Interior has also set up a specific department for these workers, and it deals with all the communications and complaints that are received from the domestic workers or from the employment agencies, and also from the employers. And a shelter was also set up, mentioned by Dr. Zeki, where any domestic worker who has a complaint or has been abused can resort to that shelter pending the examination of the case or until the domestic worker leaves the country. Domestic workers have the right to seek alternative employment instead of returning to their places of origin. I would like to say that the relationship between the employer and the domestic worker is a contractual relationship, and usually the contract is set up by the employment agency, which is authenticated by the Ministry of Interior. The regulations were adopted in 2007. They were amended in 2010 in order to provide domestic workers with more rights, and in order for them to be well aware of their duties and their rights before they arrive in Kuwait. And regarding the various decisions that were taken regarding the seeking alternative employment, there was a period of 100 days. The first 100 days of probation. During the first 100 days, the worker, or the domestic worker, or the employer can terminate the contract, and the employment agency can find an alternative employment for the domestic worker. Regarding inspection, labor inspection for domestic workers, of course, inspection in this case or in any other case is carried out in accordance with the law. If we receive a complaint that a domestic worker was beaten or held against his will, the competent authorities are informed, and the place of work is immediately inspected and an investigation is carried out. Thank you.
That when it comes to domestic laborers, we have maybe the biggest without exaggeration, I can say in Kuwait there is more than 192 nationalities. And in Kuwait, Kuwaitis are 1 million people, and the total population 2.3. So would you imagine 192 population in Kuwait? Even we have 2 people from Samoa, I think. You see. So the challenges is a lot for small societies, and we know that very well. And we are about commitments of international law and international humanitarian law. The biggest community we have, of course, are the Kuwaitis. And then comes, of course, the Indians. Indians, they represent, if I'm not mistaken, it's a huge number, around over 500,000. And then we have Egyptians, and then we have Sri Lankans, and then. But let me assure you that whenever there are violence or abuse, besides that the law, which is set to take the proper measures to address those issues, we have also cooperate closely with the countries of domestic laborers. I mean that we are in contact. There is a Indian labor attaché, there is Egyptian labor attaché, there is Philippine labor attaché, those are the communities, Sri Lankan labor attaché, and then all the time they have full access from our side to their embassies, to their attaché, how to address the issue and how at the same time find the ways and means to address any particular abusive means, you see. So this is also very important because their countries also are responsible them. We share with them and we share the views. And don't forget those countries that I gave you. I mean, like for instance, Egypt, like a sisterly country for us. And very close relationship with India, with Pakistan, with Bangladesh, so we will not take measures that at least might affect our political relations with them concerning any particular abusive. So we include them in the total decisions or in the remedies, how to find them. And even we are trying to create sometimes certain institutions one way or another to address this particular issue. This I tried to address it and try to make it sure that to see that we are open, we have nothing. And I tell you, Kuwait, we don't have single political prisoners. We don't have no single political prisoners in Kuwait. We are open to all international organizations, governmental, non-governmental. We have nothing to hide. We have nothing to hide. So, for us, there are certain things happen, we correct them, certain things we cannot. Now, concerning some statistics, I will give Dr. Zeki concerning domestic laborers. Maybe he can help us with some statistics, doctor.
Bismillah ar-Rahman ar-Rahim.
In the name of God, the compassionate, the merciful, I would like to go back, if you allow me, to the sponsorship system and to the questions posed by the distinguished members regarding the sponsorship system. I have mentioned that Article 10 of the labor law in the private sector prohibits the employer from using workers without work permits, and this is criminalized. Moreover, there are laws in the labor law governing the private sector which guarantee a sound and safe labor and work environment. The law also provides for penalties to those who do not respect safe working conditions. These laws are enforced and they are not dead letters. They have been applied, and there are certain cases in which penalties were imposed and where employers have been prosecuted, and we will provide the committee with the detailed statistics on these cases. Thank you.
The trafficking bill, the delay, and the enactment. Can you please?
Yes, Your
Regarding the question put by Mr. Newman regarding combating trafficking in persons, throughout from the beginning, I was trying to find a reply to why this enactment has been delayed. The Kuwaiti Parliament, in fact, adopted the draft law, and the delay is merely a procedural delay. The legislative authority, in fact, was slow. And this law was prepared when Kuwait adhered to the Palermo Convention and its protocols. The expert also requested some statistics. I believe that he wanted these statistics in order to find out whether the present laws do criminalize acts of trafficking in persons. In fact, these, no matter how many statistics we give you, we will not be able to combat this phenomenon. As I said, the draft law was adopted by the Legislative Commission. As soon as it is adopted, this crime will be considered a crime, and we will be able to find a definition for it that is in conformity with the definition in the convention. Unfortunately, the statistics will not be very useful. We recognize that. We do need a law, and this is why the government has decided to sit down and prepare a draft and then submit it to Parliament. Thank you. Thank you. Regarding slavery and bonded labor or forced labor, we speak based on two concepts. When such acts are carried out by a public official or somebody who is in a position of authority. And these acts are criminalized by virtue of law number 57, as was contained in the report submitted to you. In order to save time, there are other laws that criminalize these acts when they are carried out by ordinary persons other than public officials. Article 173 of the Penal Code imposes penalties on any person who threatens another person with harm in order to coerce them into doing something or abstaining from doing something. This is also provided for in Article 202 of the same law. Per remuneration, receiving remuneration for prostitution or pornographic acts will also be penalized. Whether the other person is being coerced into carrying out these acts or not. Judgments have been awarded by courts. Certain persons were convicted of trafficking in persons. Fines are imposed as well as prison sentences, and there are certain cases which are still before the courts.
Concerning Saud, also concerning violence of rape and domestic violence and all this, if you can, please.
Regarding criminalization of rape within marriage, Article 2 of the Constitution provides that Sharia is the source of Kuwaiti law, and Islamic Sharia guarantees good relations and the rights of both spouses. We believe that normal marital relations are legal. Any other relation that may not be considered normal, the courts can impose penalties if these acts are imposed by the husband against the consent of the wife. Regarding honor killings, criminal law does not define honor killings as honor killings. The law provides attenuating circumstances, especially if the son, father, husband, or a brother is concerned. And particularly when the woman is caught in flagrante delicto, and the male relative is surprised with the act of the female relative. A question was put whether this right is given to the woman. We would like here to say that according to Kuwaiti legislation, a man can marry more than one wife. However, the woman cannot marry more than one husband, and therefore, if a woman surprises her husband with another woman, then she would be the other wife. However, we cannot imagine that a woman would be caught with another man apart from her husband. if the husband, brother, or son kills his female relative, this is considered a homicide. And therefore it is considered manslaughter, and the penalties imposed are in accordance with Article 153, and the law does not define them as honor killings. We do not have statistics, unfortunately, and we do not have them with us, and we will try to give them to the committees.
It's very, very, very rare in Kuwait, frankly, very, very rare. And as a matter of fact, violence or violence within the family, in Kuwait, we are a conservative society, as a matter of fact. We don't like our issues, our fightings to come out in the streets. So from our own culture, from own perspective, we try to solve these problems within the society itself. So either the families will intervene and try to solve these problems before it reaches the police, because there is a law which they can deal with it. But however, the type of conservativeness in Kuwaiti society does not allow us, frankly, to put our laundry outside. So all the time we try to solve it inside, and we try at least to reach a compromise before it goes and registered as a case in the police. However, I think, Dr. Huda, you can tell us about, now we are in the process of creating a family courts. And then in this family courts, you can brief us, but please, I call on my colleagues to be as brief as possible. If we have to have the answer, we have exactly, I think, half an hour, right? Correct. So please, as much as brief as possible, so we can answer as much as question we can. Dr. Huda.
Thank you. Family is the foundation of society, and the law protects and safeguards the family, childhood, and mothers. The state has therefore taken all the measures in order to protect the family. The Ministry of Justice has prepared a draft law regarding family courts, which will be submitted to the cabinet, and it will then be transferred to the next session of Parliament. There are many provisions in this draft law, the most important of which is Article 8, which provides that in each district a center and a family court should be set up in order to deal with family cases and cases of violence and assault. The Ministry of Justice will issue a decision governing the work of this center and defining the tasks of these centers. These centers provide their services for free. The courts, these family courts, will be competent to deal with all cases of personal status. And in order to simplify procedures, family courts will be set up in various districts. And these courts will take up cases of personal status, such as marriage, divorce, dowry, child custody, child care, as well as other disputes. Thank you.
عفوا 6 محافظات نعم 6 yes.
We have six governors they will establish. Each one will have its own course. Concerning Dr. Saud, concerning polygamy, and you can explain this from point of Sharia and some whatever our understanding you see.
إن شاء الله.
مطلق دكتور مطلق.
نعم. شكرا سعادة الرئيس. بسم الله الرحمن الرحيم. فيما يتعلق بتعدد الزوجات أثار السيد.
Thank you very much. In the name of God, the merciful, the compassionate. As far as polygamy, the expert put 2 questions. He asked us whether this phenomenon was widespread in Kuwait, and also whether polygamy can be considered to be a phenomenon which involves discrimination against women. This is my reply now. First of all, I would like to tell you that polygamy is among the rules that are stipulated in the personal statute. We are allowed to have 4 wives. This article is based on Islamic Sharia. As far as we're concerned, for us in the civil matters and in the matters of the family, these are there are binding conditions that we must implement, which we must apply. As for the statute of the individual, there are rights, and in fact polygamy does in fact exist, but it is not very widespread. When the Islamic Sharia stipulated it, it was an exception. The normal situation is that any male individual marries 1 woman, but Sharia has required for cases where there might be polygamy, note that there be no discrimination among the spouses. It is not permitted, and in fact if there is discrimination, then there is punishment. Now, can we consider this to be discrimination against women? We as Muslims do not consider that it is discrimination or that it represents conditions, because it's a divine law. We accept it, therefore, from a religious standpoint. Now, from the practical standpoint, women themselves accept in certain conditions that they be the 2nd or the 3rd or even the 4th spouse or wife. So women consent to this. So therefore there is no discrimination. If a woman were to consider that this is an injustice, then she would never have accepted to be 2nd or 3rd or 4th wife. This is as regards the religious statements on polygamy.
كنص في وكذلك أحكام صدرت من المحاكم بأن المرأة تستطيع طلب الطلاق للضرر.
As we all know, there are legal texts that do stipulate that a woman can ask for a divorce. If a man marries a 2nd or 3rd wife, then the first one can withdraw from the marriage by asking for an annulment of the contract if his 2nd wife is taken by the husband. Now, as far as property and inheritance, my colleague has already referred to it, and at the very beginning we said that all rights are equal between men and women, except as regards Islamic Sharia and what is stipulated by Islamic Sharia. In fact, as you know, we base ourselves on the Sharia as single source, unique source for legislation on an everyday basis. Now, as far as property goes, one of the distinguished experts put a question to us about property and inheritance. These are 2 different subjects, I should say. Property is an area or domain where women are equal to men. So this is completely different from the situation with regard to inheritance. The wife is allowed to be an owner of property as we have it in Article 4. We were told that there was injustice in some cases, in certain issues, but from my side I wanted to clarify this. There are several different types of property. In some cases, it is permissible for a woman to be an owner through a direct purchase or through a loan. We have a law that dates the date of which is 2011. This is a special plan for savings and acquisition of property. Women are completely equal to men in such cases, and women can obtain a loan, a mortgage loan. Now, in the past, the law allowed for the purchase of goods and real estate to families, even non-Kuwaiti families. If a woman is Kuwaiti, she is entitled to take out a mortgage loan, which is called a family mortgage loan. Thank you.
To Islam, and when we say it is, our religion is Kuwaiti Muslims, we know that Islam is a religion, also it's a way of life. That's the difference where sometimes there is overlapping. It's a way of life. It can, in Islam, define our life, and it's our laws. However, international treaties and international law, we consider it part of our also law. But you see, at the same time, you see, we try as much as possible to the major important things in Islam, we respect them. We cannot touch them. We try to, as much as possible, to find solutions where we can combine both things together. But believe me, in Islam, as well as in the covenants and international treaties, their aim is the same, is equality of a human being. Whether it's our religion or whether it's the covenants or international treaties. The aim is the dignity of a human beings, respect of a human beings, and the well-being of a human beings. From that perspective, we do not see any kind of contradictions. We see sometimes a way of life where you can, and I've seen it in different cultures, in Hinduism, in Buddhism, in a lot of where where there are corporations between your culture, traditions, and habits, and also with international law and with international. The aim of it is the human being, the center of it. And then you can create a debate where is, we started long time, we started civility when we were, in the jungles till we reach whatever we reach right now, you see. We develop, and absolutely human beings will take the best from all for the dignity of the human beings. That's the aim of it, and I do not see any contradictions between the two things together. Now, when we come to polygamy, for instance, and I have raised it in CEDAW, polygamy, if you tell me 100 years ago, 200 years ago, yes, there was polygamy, and the rate, and it's very high. But if you tell me right now, in this age, I mean, it differs. We are human beings, and the society develops towards less and less and less and less, not towards more and more. Before I tell you, I am a son out of 16 brothers and sisters. And then there are different things. During that time, maybe I have another mother, helps another mother to live, to help them. We were poor, we are a lot of things, you see. So the society puts for it some certain needs where But right now, we don't see, frankly, a man, he is graduated, for instance, from Harvard or a girl from Princeton she's going, of course, different ideas now, different perception, different mode of life. Before, maybe family extended. Now, no. Now it's more the family is less and less because it's the quality of family in which you want to raise for better education, better health, better that. So what we do with, when you have, now two marriages. One wife now, it's a lot of responsibility, you see, and it's a lot. And even myself, Madam Chairperson, I'm not married at all, you see. So it, now this is discrimination. So the idea is, this is now when you look to my sisters, it's different than my mother, and maybe the future will be less. Now, as I tell you, she doesn't want more than 3 children or 2 children, not because the religion said no or yes or that. No, because this is life, how you develop the quality of life you want in the future. So that's what I meant to say, that we are walking in a way, but let not, be rigid concerning A or B. No, it's not that's the issue. The issue is how to develop society to be dignity, or, I come to you here, not in court of law, you do this or do that. No, I come to tell you exactly my own experiences. I benefit from your experiences, and we seek the best. That's the aim. You see, this dialogue creates a hell of development in our thinking, you see. And also you will understand a lot about own cultures and about a lot. You see, when I traveled all over the world, I found I never ridiculed a small culture. I respect them because there is something behind this culture all the time, whether it's in Africa, Latin America, in Asia, in Arab world, in China, in everywhere. So you understand this life and you try to, to develop. So right now, frankly, when we reach the polygamy, it's much, much, much less. And if I have the statistics, they correct me, my colleagues, it's now below 9%, much, much below, you see. That's what the society, this point just I want to raise it up in front of the committee. Concerning, I think, concerning the appointment of the judiciary of a woman.
فيما يتعلق بتولي المرأة القضاء، الطبيعة القضائية بوصفها محامية دولة بإدارة الفتوى والتشريع.
There seems to be a technical problem.
إن المرأة في الوقت الحاضر تتولى.
Currently, women have attained very high-level posts. You can find them at all levels of the judiciary. In some cases, they are lawyers in advisory services of the state, for example. They can also be attorney generals in investigation and research services in the Ministry of the Interior. In some cases, they might also be judges, arbitrators in some courts. They also participate in a number of different commissions which support judges in the courts. Article 19 of a ministerial decree which organizes the justice system, the judiciary, it stipulates the criteria which are to be respected to work in the judiciary. Among others, there are 5 conditions which must be fulfilled before a judge can be appointed. But nothing would stand in the way of a judge being a man, and nothing would stand in the way of a woman being a judge. This has been reiterated by one of the chairs or presidents of one of the main courts. He made a statement during a press conference saying that a woman was not prevented from becoming a judge. We are all awaiting a complaint which will go to a court requiring a post as a judge. But this time of judgment has not taken place. There have been no complaints.
And then the one who should decide on that, it's not also the executive branch, it's also the legislative branch. I mean the courts. And this debate is a healthy debate. And it started for a while. And I think it started when we presented our report of human rights to the UPRs. And in the UPRs, we said the same, that this healthy debate is good. We try to match our constitutional responsibilities and laws before we can proceed towards any ensuing law. But as he said, there is nothing forbid, there is nothing say okay. But it is a debate going on, and we hope that this debate will be fruitful and will reach, we hope, a very good conclusions in the future. Concerning Saud, concerning the homosexuals, and then there is the other section, I'll give it the society to the Ministry of Social, of Dr. Zeki, concerning the Society for Homosexual, which were rejected in 2007, or Amina, one of you. Saud, go ahead.
فيما يتعلق بنص المادتين.
As regards the texts of the two articles 193 for consensual homosexual relations, and as regards the practice of homosexuality in public places, the law in Kuwait provides for sanctions which respect Kuwaiti traditions, because Kuwait is an Islamic state and Kuwait has Islamic traditions. And a judge may decide to apply the law in a rigorous way, or can be flexible and make the sanctions lighter, whilst taking into account the circumstances of each case and studying carefully the details of the case depending on the character of the person, homosexual or not homosexual.
Homosexual Society, when they presented in 2007.
شكرا سيدي الرئيس.
Thank you very much. Thank you, Madam Chair. I apologize for having said Mr. Chairman. We have not received any complaints about the creation of a homosexual organization. If we were ever to get this sort of request for the creation, the setting up of such an association, the request would be examined, would be reviewed. We have Article 24 of 1962 concerning the setting up or creation of clubs and associations, and the case would be examined at the proper time.
الرحمن الرحيم إضافة.
In the name of God, the merciful, the compassionate, in addition to what was said by my colleague Amina Hall about the establishment or setting up of organizations for homosexuals, I'd like to explain that even if a ministerial decision rejected such a request, that decision would not be definitive. The decision is definitive from an administrative point of view, but from a legal point of view, those who submitted such a request may appeal to other courts in order to quash the first decision from an administrative point of view, and it is even possible to annul the ministerial decision, and such an association could be created thanks to an appeal to a court. Those who have submitted such a request for the creation of a homosexual association chose not to go to the appeals court for the matter, and they're entirely they have the right to appeal to others.
تجريم لو سمحتوا لي أن تجريم.
I would like to give you a detail about slavery. Article 57 of Law 31 of 1970 criminalizes slavery, and this is consistent with the text of international conventions which the state of Kuwait has adhered to, in particular Convention 29, Convention 105, which prohibit slavery and which criminalize forced labor. These texts of international conventions are consistent with the legislation in Kuwait. In addition to the criminal laws and criminal sanctions, we have a number of ministerial decrees and decisions which come from the Ministry of Social Affairs, which prohibit completely slavery. And
Ministry of Justice is, the debate we have.
Yes. في شأن استقلال السلطة القضائية.
Now, about the independence of the judiciary, Kuwait has recommended having a system of separation of powers, and this stresses the independence of the judiciary. Article 162 of the Constitution stresses the importance of the independence, of the judiciary, the integrity, because this is the best guarantee to protect rights and freedoms. The Constitution stresses honesty, integrity, and integrity of judges, because this guarantees fundamental freedoms. The purpose being to guarantee independence. Article 163 of the Constitution requires that the judge should have full independence, and it should not be possible to end the judge's contract. Now, as to the question that was put, with regard to the employees of the judiciary who come from outside Kuwait, we have contracts with Egypt, for example. Egypt has loaned or seconded a number of judges to us who work in Kuwait, so this is done in accordance with contracts entered into with the State of Egypt. Some say that in view of the fact that these judges are under contract, at any moment they could be removed. And we've been accused that we can at any time end these contracts, and that this put some doubt on the independence of the judiciary in Kuwait. That is false. These are judges from Arab countries. They are here in our country, in Kuwait. The Emir of Kuwait protects them. And there's no difference at all between national judges, in other words, Kuwaiti citizen judges, and Egyptian judges. There are no differences whatsoever between these judges who come from outside Kuwait, who are on loan to us in accordance with a convention that was signed between, as an example, Kuwait and Egypt.
You respond to the harassment, Doctor, for the homosexual harassment. Saud, Dr. Saud, harassment. إشعار. من عنده Kuwait. Concerning I would like to make a little bit some clarification for the distinguished experts here. Concerning stateless, frankly, when you look to the treaty itself, you know it's when it was created after World War II, and exactly what is behind that treaty. In our case, frankly, we don't have stateless per se, if it's in accordance with that agreement, with that treaty. However, we have people who come to Kuwait to work, to live from the time we started, oil started in the late 40s, beginning of 50s. So the wealth brings a lot of people towards Kuwait. But why, when we come to the issue of those people in Kuwait, they want this? Why we have this problem, for instance, of what we call them the illegal residents, which they call themselves Bidun, and then they are objecting between using which definition. Kuwait, first of all, it's 1 million people. Kuwaiti is guaranteed by the Constitution to full health services. And if this health services is not available in Kuwait, we bring you anywhere in the world. Here I am in Geneva. I have plenty of Kuwaitis, whether children or whether older, whatever, men and women, they come for treatment. They are allowed by the law. If we cannot supply it for them in Kuwait, we are obliged to take them outside. When you come to after graduation, you are allowed, housing is stipulated in the law. And then after graduation, you supposedly government has to give you a piece of land or it gives you a loan over $300,000, and then of course it's you, or they supply you with a house. So housing is also guaranteed by the law. Also, you have subsidies of food. Food is subsidized by all. Electricity is, of course, subsidized for all. Petrol, gasoline, subsidized for all. And there is no what we call tax system. We do not have tax system. Nobody is taxed in Kuwait. You see, either your wealth or it's on your, whether Kuwaitis or non-Kuwaitis. There is no income tax, no, nothing. I tell you. So there is a lot of privileges allowed with the nationality of Kuwaiti itself. Education also is free. When we do not have in the 60s universities, we resort to send them to Egypt, to Syria, to India, to United States, to London, to the West, to learn and to come back. Even now, in certain universities in which we need certain things, we send for the Kuwaiti, and it is free, no charge. You see, that's the difference why they make the country, it's everybody, he wants to be a Kuwaiti. And not only that, that's what we say sometimes, the issue of nationality is a matter of sovereignty. We differentiate between two important things. Between nationality, to grant nationality, to get all the privileges which you have, and when between your rights as a human being, where we offer you the rest of other things when you are resident in Kuwait, that you have. From human rights perspective, from humanitarian, we allowed to have certain things. And then if I tell you, we are not shy from helping the illegal residents, or for how many? Kuwait established Kuwait Fund. We are helping Africa. We are helping Latin Americans. We are helping India. We are helping programs, billions of programs. It's not matter we do not have the money it's a matter of sovereignty. It's a matter of changing a demographic society of yours. You have to be careful when it reaches, changing the demographic society of a country. But absolutely, if there are people who deserve certain rights, we'll never hesitate, you see. Those my people, I speak because I know it's 6 o'clock, I will stop. But tomorrow I will let my people of the illegal resident, they will respond comprehensively by statistic exactly what we have. And I tell you, we help a lot of people outside, billions. For Hurricane Katrina, we gave $500 million because, only for, to our commitment to the United States of America when they helped us during the invasion of Iraq, you see. So I'm telling you in general, this is in general, but I hope tomorrow we'll comment more specifically. Thank you, Madam Chairperson.
Thank you, Ambassador Razuki, for your responses and the responses provided by your delegation. We shall devote the first 15 minutes tomorrow to complete the responses to this first set.
Yes.
And for now, I adjourn the meeting.